Let's go back to the statement made by Mr. Feigenbaum several times about 6,000 babies born out of the state going into New Jersey.
We have, in New Jersey, 6,000 babies born out of state every year. When they come into the state and they need benefits, the Boyle Declaration from Massachusetts suggests that's going to cover 40% of kids. They come into our state, they need benefits. We have to do citizenship verifications, which is a burden for us.
That's for you in New Jersey, but there's, I think, how many states?
That's just an example.
So I think I figured it out. If SCOTUS says these courts can only issue injunctions or restraining orders for the parties to the case, then what happens when said order only impacts one or two of the 50 states? In this case, some states would award citizenship based on birth, others based on the citizenship of the parents. Now, according to Mr. Feigenbaum, that means a child would be a citizen in one state but not another, forcing New Jersey to re-verify the citizenship of every child who applies for benefits. Is that how it would work? Yes, under those circumstances, a child would be a citizen if born in one state and not another. Then if a child born in one state is not a citizen, do they suddenly become one when they cross state lines? Well, the answer is not unless Congress passes a law that says they do. So far, no such law exists, which means Mr. Feigenbaum's next statement doesn't make much sense.
So individuals will move in. When they were born, they were treated as non-citizens. They didn't get Social Security numbers because they wouldn't have been eligible for the enumeration at birth program in their states, and they're going to arrive and they're going to seek benefits that we administer. But federal law requires that they have Social Security numbers for the administration of those benefits. This is 7 U.S.C. 2025 for SNAP. This is 42 U.S.C. 1320b7 for TANF, for Medicaid, and so on. So they're going to need to have Social Security numbers. They're going to arrive without them, even though they were, under this Court's precedents, citizens who should have been in the enumeration at birth program, who should have had Social Security numbers. And it's going to be a burden on us, either in delaying the benefits, training county social service workers, in having to administer benefits without the SSNs on a provisional basis.
Federal law requires a Social Security number to receive benefits because it requires these benefits be for citizens. If a child is not a citizen, they don't have a right to benefits.
And then the last point is, we've never in this country's history since the Civil War had your citizenship turn on when you cross state lines. So we don't have answers to these workability questions, not just because it wasn't presented in the district court, not just because it's 2 sentences in an emergency application, but because for over a century, executive practice has been uniformly to the contrary, building on this Court's decision in Wong Kim Ark. So we genuinely don't know how this could possibly work on the ground.
That's because citizenship doesn't change when you cross state lines, whether you're dealing with someone born overseas or in one of the United States.